doing, how KSL is so far. Sorry, I haven't asked if you guys are able to hear me, but I believe you can. And so we can just start from any of you. Maybe you can just update us. You can just talk to us. Let us know how is it? How are things so far? How are project work? Have you guys already submitted your work? How was that process for you? Just to break the ice before we start. So is there anyone who'd like to just greet us and update us on such? Anyone? You can just raise your hand. Let us know how project work goes for you and how things are going on so far. And probably you can also just tell us or let us know what you'd like us to improve on, even as we continue with these sessions. Anything that you are missing, anything that you think that maybe we can discuss or tackle, it will be nice to hear from you. And feel free. We are just advocates like you. There's really no difference. I don't want to say Gen Zs, but yeah, there's really no difference. So we can have a conversation. There's no problem. So anyone who is willing to update us on that, anyone, you can just say hello to us also just before we begin so that we're able to hear from both sides. Is there anyone? Or I'll just call the names I'm seeing. Anyone? Okay, I can see Mwendo Sharon. Sharon, maybe you can say hi to us. Let us know if you've already submitted your project work and how the experience was. Or we have Ochieng Abur. Go ahead.
Okay.
Oh, sorry, Sharon, you can start, then we'll have Ochieng. Sorry.
Good evening to everyone. My name is Mondo Sharon. I'm in class F, and so far so good. The project work has been hectic from left, right, center, but we are managing. But we thank God we've been pushing through, and we have finalized most of our project. It's just one or two things we are polishing up on. But the orals that are upcoming, they're really stressing most of us. But I hope by joining this session that I've been joining with you, I'll be able to polish up on my end. And and thank you for giving us this opportunity and sparing time to help us go through the oral session. Yes.
Okay, that's nice. Nice to hear from you, Sharon. Yeah, sometimes I can remember when I was preparing for my orals and I had no idea at all how they're done, how it's gonna be. People are talking about ambulances waiting for those who faint and everything else, and it looked like it's something that is really, really crazy. And I think the reason as to why we are here is just to hold your hands, just to let you know how it is, how it goes, and to help remove or reduce that anxiety that I know that sometimes we can have. So I hear you, Sharon. I hear you. Now, one tip that I can give for the project work is please just ensure that you work together so that if you fail, no one will say you did the work alone and you're the stupid one. And if you get good marks, at least it will belong to every single person. Of course, I know all of you guys are going to pass. And again, we always have different opinions. And again, man is to error. I could go through something and say it's crystal clear, but really there's a mistake here and there. So just try and work with the rest, and it will really be nice. Thank you so much, Sharon. We can have Uchieng. Uchieng. Uchieng Abur.
Hello, good evening.
Good evening, sir.
Okay, so this is actually my first time attending this session. I've never attended it. And I also have some sort of expectations. I believe by the end of this session and by the end of these meetings, I'll be able to gain more regarding orals and also regarding the upcoming exams. Personally, I think the project work has been like a sort of laying a foundation and also a ground for the subjects that we've been doing. And the discussions have been effective, even though sometimes people tend to get tired, energy level reduces, and also the psyche reduces. But I believe with everything that we've been discussing in the project work and also regarding the current issues, I believe that even in the upcoming examination and also the oral ones, I'll be able to tackle them really well. Yeah, I'm not quite sure about those specific questions that people usually revise through. I'm not actually familiar with them, but I've just managed to go through the extensive part of the units and also reading them extensively. Yeah.
Okay. Thank you. Thank you so much. Thank you so much, Uchieng. That's quite clear. Yeah, I know during this time we have the books where you'll see questions for orals and everything else. And sometimes it's very important to go through those books. Yeah, it's very nice and very good. At least these guys are able to predict some of the questions. And again, yeah, these questions keep changing all the time. Yeah, but just to maybe reduce your anxiety, it's okay, it's doable. Just keep the way you're saying you keep preparing, just keep preparing yourself, and it's gonna be okay. Now, even as we proceed, I have a friend of mine here where I am who I did orals with. So I'd just like her to give you guys a few tips and just to answer some of the questions or just to speak to some of the things that you've talked about, Ochieng, and I hope it will be helpful. She's called Nashipai. Nash.
Hi guys, how are you? I hope you're all well. Hi Osumba. So what I'd say is if there's one piece of advice I'd give myself looking back, when I was preparing for my orals is to, of course, know a bit of everything, but then again, delivery is everything. If you are composed, you're halfway there. And all of these things are familiar to you. You've done your exams, you've done your degree, you made it this far because you're competent and you're able to take it on. So long as you're composed, there's no battle that you can't win. Just be prepared, take it easy, take yourself slowly. You're not in a race against anyone except yourself. If you feel you're flustered, just start again. It's going to be okay. Those people are human. The questions may sound strange, but if you take a moment to just digest what it is you've been asked and then unpack it in a logical manner, you'll make it through. Us guys made it through, even though we didn't even have the kind of guidance that Daniel and Collins are giving you. So I can assure you, you're going to do very, very well in your orals. God is on your side. Just take it easy. Yeah.
Okay, guys. I hope that was loud and clear. So basically, let's just continue with the same spirit. I will not reiterate what she has said, but I hope that we've heard what she said. Osumba, do you have anything that maybe you'd like to add before we begin?
Hi everybody. Not really. Just to acknowledge Nash's greetings. But I really hope everyone is keeping safe and glad to have you guys here. Thanks, man.
Okay. So do we have anyone else who would like to say something before we begin this session? Is there anyone else who'd like to say something? Thomas, I don't know if you're there. Maybe you'd like to greet the class.
Hi, Daniel. Hi, everyone. Thank you for the time. Mine is just to wish all of you success. And the success begins even by attending such sessions. They are very important. Some of us are beneficiaries of it. And that is what inspired us to be part of it. And I just want to assure you, you do your best, take the learnings that you're picking here, and it shall be well. I mean, oral, you will just has it if you follow the simple things that are going to be highlighted in this forum. Otherwise, Daniel, thanks for reminding me to be here, and I'm ready to learn as much as I can and also impact the little that I do have. Thank you, and let's enjoy the forum.
All right,
Thanks
thanks.
over to you, Dan.
Okay. All right. Thank you so much. Thank you so much for that. Okay, guys. So I think we can begin. We can start the session. Unless there's any burning question from any of you. Is there anyone with a burning question? There's something that maybe you'd like to ask us before we begin the session? Anyone, any questions? We like giving people this time because sometimes when we are done, everyone is so tired and you just want to go and sleep probably. So is there anyone with a burning question that maybe you'd like to ask even before we begin? Anyone? Please, as we always say, feel free. Feel free. Yes, I've seen there's someone with who has raised their hand. Please go ahead.
Yes, good evening. My name is Susan. So I wanted to ask about the panelists. Do we know them beforehand, or it will just be a surprise, for lack of a better word? And then you also asked about the submission date for our project work. It will be between 16th and 18th of this month. Then we will begin our orals on 22nd. Thank you.
Okay, that's nice. Thank you so much for greeting us also, Susan. Yeah, and thank you so much for those dates. So 22nd, that's okay. We still have time, of course, as we prepare and as we do our best. Now, the panelists, you want to know your panelists. You won't know them until that day in the morning. Probably that's when you'll know who is in your panel. And when KSL we were told, if you know these guys earlier, you can start, the deep state. Start calling who knows the lecturer, so that you have a conversation and see how you're going to get your 19. Yeah, so normally you're not able to know the names up to that morning when you're going for your oral sessions. And I think for me, we were only able to know because the people who went before us and they knew the people we were with in the class, and they're able to text us and tell us, oh, it's this person and this person in the panel, and it's this person and this person in this panel and this and this. So you won't know up to that day. But again, please, it doesn't, for me, and I think Osumba will also say this, it doesn't really matter who is in your panel. Most of the time, you just take it as it comes. Just be composed and just do your thing. Just do your thing, and it's going to be okay. Again, one thing that Osumba likes saying, and probably Limble will also reiterate today, is these guys do not come that morning to fail you. No, that's not their interest. They don't come there to fail you. They just want to know what you know. Basically, they don't wake up in the morning and say, today I'm going to give them 3, 3, 3, 3, 2, 2, 5, 5. They just come to know what they are very fair. Most of the time, I think for the lecturers who are there during my time, and I think it's still the same lecture, they're very, very fair. They don't wake up in the morning and decide that they are coming to fail you. No. And I don't think that's part of the job. They just want to know what you're doing, and they just want to know if you know and if you're able to pass your orals. If you realize it's oral exams, meaning it's about speaking, presentation. How composed are you? Are we able to hear when you're speaking? Are you able to explain yourself? If you are in court today, would you be able to represent someone? How would you speak? How would you explain yourself? Would the judge be able to hear you? Are you able to use the correct words here and there? So basically, that's all they'll be looking for that day. Nothing much. So easen up. Even if you don't know them, or even if you know them, it's going to be okay. So don't let that be a worry. Even though you want to know them, please don't let it be a worry. Okay. I bet we don't have any other questions. And so we can begin. We can begin.
Daniel, we have
Yes?
one more. Someone called
Okay.
Muendo.
Nice. Angela is in. That's great. Go
Someone
ahead.
called Muendo. His hand is up. His or her hand.
Hi. Mine is just a clarification on the orals. For example, you said pass in a question, and when you answering another question, you remember the answer to the previous question. Can you go back and answer that question that was previously asked that you had already passed?
Good question. Good question. Osumba?
Because as I've always said, you're at liberty to go back and answer whatever question you passed. So that is allowable. Well, also one thing that I wanted to address as a preliminary issue. The last time we were here, we had this conversation about special limited grants in cases where somebody wants to, for example, access money that is held in the bank account of a deceased person for the purposes of paying school fee and all that. Of course, the position, the correct position as per, what is in law is that you are to apply for special limited grant. I later on saw in the chat someone saying that courts have allowed people to access money to pay school fee through an application for granted gender bona defuncti. As you guys will realize when you proceed for your pupillage, is the practice of law in the real world is a bit at variance with what you're taught in school, because then, as practitioners, we make mistakes every other day. And you go to court and you invoke Article 159 and, issues of technicalities and all that. So sometimes the court may be lenient to grant you orders, even if you use the wrong vehicle to go to court. But for the purposes of passing your exams, because I think that's why we're here, to have you guys pass your exams, restrict yourself to what is provided in the law and not what necessarily emanates from jurisprudence, unless it has been made part of the curriculum, like the decision of Justice Weldon Correll that indicated that you can actually seek for judicial review orders through a constitutional petition. So right now it is part of the curriculum, because I remember even in our exams, I did, in our civil litigation exam, the first question was something on judicial review. And I actually did a petition, and I performed it. So many other people. So guys, to be safe, don't bring in things that have not been adopted. Just restrict yourself to what is taught in class, so that then you're able to pass. When you jump over to this side, it's okay. We are here to develop the law, and you can do all that. So thank you. I wanted to address that.
Welcome. Guys, I hope that was very clear and you're able to hear what Osumba, you've been able to hear his submission on that particular question. Okay. Angelo, do we have any other hand that is raised?
No, we don't. I think we
Okay.
can begin. Yes.
Yeah, we can begin. Thomas, I think maybe you can start us off, noting that you haven't probably had the chance for a while. But yeah, you can start us off. Maybe you and I think Donna, are you in? Donna? Did you manage to join? Donna? Okay, Donna is not there. So I think you can start, then you and Osumba can do the first session, then me and Angelo will do the next session. Thomas?
Okay, thanks, Dan. I don't know what has been the approach since this is my first, but maybe I will just borrow from the previous experience in the last year's category, which I was. So that time people used to offer themselves. I mean, guys from the plenary can just offer themselves. Whoever wants to be asked questions, then they can offer. I don't know whether that still stands or I'm meant to choose whoever I want. I seek your guidance on that.
You can ask for for a volunteer, then you'll be able to proceed.
Okay, thank you. Now, who can volunteer so that guys, don't be afraid. Assume now we are the panel and you are facing us. So just volunteer. Anyone? We will not grill you. Yeah, I see Kimathi, Kanana. Okay, fine. All right, now unmute.
Hi, good evening.
All right, now assume that it is a morning session. So I want you to introduce yourself.
Thank you. Good morning, Mr. Thomas. My name is Kanana Kimathi. I'm a student of Kenya School of Law undertaking Advocates Training Program. I'm in Class B, Form 15, and I'm here to undertake oral exams, which is a prerequisite for my admission to the bar as a in partial fulfillment of the requirements that are required for me to be admitted to the bar. And yeah.
All right, good. Now we will jump into what you have come for here. Now, have you ever heard of the term jurisdiction?
Yes, I have heard of the term jurisdiction. Jurisdiction refers to the power of the court to determine a matter at hand, and we have different types of jurisdiction in various courts. And also, just to state that in Samuel Masharia's case, one of the things that was noted is that jurisdiction is everything and a court cannot arrogate itself jurisdiction. So in summary, jurisdiction is the power of the court to determine a matter, but it has to emanate from the constitution or an act of parliament.
Great. You, in your definition, you have just you indicated that there are types of jurisdictions. Could you mention those types?
Yes, thank you for that question. So we have pecuniary jurisdiction. This refers to the power of the court to determine matters, but the limit is on monetary limits rather, where, for instance, in the magistrate courts, there are different pecuniary limits that a court can listen to, from all the way to Chief Magistrate Court, which is 20 million, and then we have senior principal okay, let me just start from the bottom. So we have the resident magistrate courts, 5 million. Then we have senior resident magistrate court, 7 million. Then we have principal magistrate court, 10 million. Then we have senior principal, 15 million. And then we have the chief magistrate court at 20 million. Then we have the courts above, that is the high court, which has jurisdiction with respect to 20 million and above. Then we have territorial jurisdiction. This speaks to the place where the defendant resides or where the cause of action emanated from. Then we have subject matter jurisdiction. This is where the court determines matters with respect to the different subjects that arises from those matters. For instance, I'll use the example of the Environmental Land Court, as well as Employment and Labor Relations Court, where we have the Employment and Land Court listening to matters that emanate from land issues, and then the Employment and Labor Relations Court emanating from employment matters. Another one that I can remember is original jurisdiction. Also, this is where the court has, this is where a matter can start or can originate from that court alone and not any other court. So yeah, those are the ones I can remember at the top of my mind. Yeah.
Okay, just along that line, you have mentioned of original jurisdiction, and I want you to cite for me some of the courts that will exercise that original jurisdiction.
Okay, thank you for that question. So in attempting to answer that question, I'll go with, for instance, the High Court under Article 165. We have the High Court having original jurisdiction to listen to questions with respect to civil and criminal matters. And also we have the High Court jurisdiction to listen to any question or matter that emanates from a determination on whether anything said to be done or ought to be done has violated the Constitution. We also have things to do with jurisdiction of the High Court with respect to violation of constitutional rights. When you go to the Supreme Court, we also have original jurisdiction under Article 163 to listen to presidential election petitions, as well as Section 58 on declaration of state emergency in terms of the validity of such declarations. At the Magistrate Court, we have original jurisdiction with respect to certain criminal matters outside other than the capital offense of murder and treason. Yeah.
All right, I think that's enough from me. Let me hand you over to Osumba. Thank you.
Thank you.
Good. It's evening, but how are you, Wakili? How are you?
I'm very fine. How are you?
I'm doing well. Just a follow-up on the issue of jurisdiction. Which is the smallest court in the land?
Thank you for that question. The smallest court in the land will be the Small Claims Court.
Assuming you are an advocate representing a plaintiff who has sued the government for malicious prosecution, the government was duly served. They have not entered appearance, neither have they filed a defense. What would be your course of action as counsel? What would you do to protect the interest of your clients?
Thank you for that question. So in attempting to answer it, if I'm representing my client who has been faulted by the government, as you have rightly stated, I believe the best course of action at that stage will be applying to the court for default judgment, if I'm not wrong. I'm not quite clear, conversant with that issue, but in trying to attempt it, I'll go with default judgment to be entered with respect in favor of my client, because if and then also I will show that we had duly served the government, and also we had served all the necessary pleadings before the court within the stipulated period. So I would ask the court to issue judgment, a default judgment in favor of my client. Yeah.
I agree with you. However, what you have failed to include, because if you look at Order 10 Rule 8, it directs the manner in which such a situation is to be remedied. Yes, you will ask for default judgment, but the catch is you cannot ask for default judgment against the government without leave of the court. And so you have first to make an application for leave, and once leave is granted, is when you now apply for default judgment against the government. I hope that is in order. My last question would be, would you be kind enough to differentiate for me a caution and a restriction?
Thank you for that question. Yes, I will. In attempting to answer the same, I believe a caution refers to an action that is taken by a person who has an interest in land of someone else, but the main objective of a caution is the person will be creating a condition that if any other person wants to use interest in that land, they will have to first seek consent from the cautioner, the person who has entered that caution. And for a caution, and then now a restriction, this is equally an action that is taken by a person with respect to any disposition that may be made in that land, or any action that may be taken in that land. You have first to consult the person. But in trying to make the distinction, I believe a restriction is made by the owner of the land, but a caution is not made by the owner of the land. The cautioner can be someone else, but not the owner of the land. But a restriction is entered by an owner of the land. Yeah.
I think that is sufficiently answered. Contented. Thank you. Thank you very much.
Thank you.
I think maybe you can give your comments. Maybe you can start with Lim.
All right. Thank you, Dan, and thank you, Kanana, for availing yourself. The first thing I would want to, first, you have done exemplary well. The only thing I want you to avoid, you are starting by in attempting to, almost every question, in attempting to. My advice is just avoid that. Just answer, go straight, and leave them to judge. And one thing I like about your way of answering is you are onto the point. And in fact, even when if you have the law, start with the law, and then you go to the point. Just hit it. As I remember when we were doing it, I think Angelo used to say, hit it on the head, or it can't, but he was saying something to that effect, as in just go straight to the point, and you are doing that. So that is one thing I really like about you, but avoid that thing. I mean, those phrases that will indicate you are not sure of what you are saying. I think that is the much I can say, and the only emphasis I want to put is when you talk of okay, you cited the High Court having that original jurisdiction, and that is true. I was a bit jittery when you mentioned the magistrate court. I think the magistrate courts, they are the subordinate courts, but when it comes to original, I think it's a matter of practice that they are given, the High Court gives them, or the law gives them that mandate of starting with some cases that they should start there, so that the High Court enjoys, I mean, has that appellate kind of jurisdiction, appellate jurisdiction. But the Constitution actually clauses the High Court, courts of equal status, and the Supreme Court with the original jurisdiction. I think that is the starting point, and then you go to, you can just say the magistrate court, just like the way you have done it, but put it in your mind that the original jurisdiction actually lies. The first court that comes in your mind is that the High Court enjoys that original jurisdiction. And maybe just something that I need to say in regards to something that helped me when, and I like saying, be creative when you are revising. It makes your work easy. Creative in the sense that you come up with some creative things on how to grasp concepts that are there. Now, for me, when I was dealing with the question of jurisdiction, I used a certain acronym, and the acronym that I used that time that helped me was I used the PIGA, the Kiswahili word, just PIGA, and then LOFSU. And that for me encompassed all the types of jurisdictions that you can have. So I had PIGA LOFSU. When I talk of jurisdiction, what used to come in my mind was PIGA LOFSU, because pecuniary jurisdiction, P being pecuniary jurisdiction, I inherent, G geographical or territorial, A appellate, L limited, O original, and then F first instance jurisdiction, and that is now when you go to the subordinate courts, they have this kind of first instance jurisdiction, second instance jurisdiction, and then unlimited jurisdiction. That summarized for me. And I like the fact that you cited the case of SK Macharia versus, I think it was, was it? Yeah, I think it was Communication Authority, but the case was SK Macharia. But the Locus Classicus case, which I was expecting you to say, but the SK Macharia, for the very reason that it was determined by the Supreme Court, of course, made a lot of sense. So that, but don't even forget the Locus Classica case of, is it owners of motor vessel Lillian S, something like that, the Caltex versus Caltex, that case. So, but generally, you are good to go. Just refine and refine and refine, and my goodness, you may end up getting 19 or 20 out of 20 if that is practical. But I was very happy with your responses. Just minimize the small thing that I pointed it out. Over to you, Osumba. Thank you.
I don't have much. I think you've captured it well. You see, if you say in attempting to answer that question is the equivalent of correct me if I'm wrong, it makes you appear unsure, it makes you appear uncertain. Another, you have sufficient knowledge, be sure, and you're gonna ace those exams. You did well. I would have given you a 16 because you deserve it. Thank you. And of course, now just to correct you, you see a caution, of course, as you rightly pointed out, you can't caution your own land. Any other person who has an interest on it would then put a caution. Restriction of on the other hand is put by the registrar, either on an application by a registered proprietor or suo motu. Cases in point is in the circumstances or in situations where land needs to be compulsorily acquired for use by the government or government entity, then the registrar would suo motu restrict or put a restriction on that land. And that is that. Thank you.
All right. Oh, that was a lovely session, and I think you've done very, very well. Your answers were very, very nice. I see there's a raised hand, and thank you so much, Osumba and Thomas. That was good. That was great. Yes, there's a raised hand. Wekesa, you want to be next?
Yes.
Okay, that's good. Angelo, just so that I'm fair, could there be anyone who had raised their hands before Wekesa? Because I know you can see.
So far we have a case.
Okay, we only have Wekesa. Okay, I think I saw someone. But anyway, it's okay. Wekesa will go with you. And I think for gender parity, let's have a man now. Okay, so
We have
how are you?
someone called Chep. You have lowered your hand again.
Okay, maybe they'll come.
Cheptangat Levi.
Sorry, guys. Sorry, I'd raised my hand. I wanted to a clarification on the issue of restriction, and it was actually clarified. So, yes.
Okay.
I can volunteer next
Okay, then
after.
probably after Wekesa.
Yes.
All right. So Angelo, it's me and you. We can go with Wekesa. Then after us, we can have Lim and Donna after us. Then I think we can have. I mean, we'll see from there. Okay. So Wekesa, you can just unmute. How are you?
Very fine. I'm very fine.
Okay. Kindly introduce yourself.
My names are Richard Kamau Wekesa. I am a KSL student. I'm here for the oral examination, and I'm hopeful to have a nice engagement with the panel. Thank you.
Welcome. I'll ask you a very easy question. What's the meaning of oral exams? What do you think this exam is for?
In my understanding, the oral exams are meant to gauge a student on the general understanding of the law, and to some extent to gauge your deeper understanding on what you have been learning since your LLB to this particular point.
Okay, that's fine. Now, a good friend of mine used a word today that was quite interesting, and the word was suomoto. What is that? I don't understand. Could you maybe explain to me what that means? Suomoto.
My understanding of suomoto is that it is a Latin word to mean voluntarily.
Okay, so I bet he meant he did something, or the court did something voluntarily. Okay, that's okay. That's fine. Now, I'd like you to differentiate to me these two documents. What is the effect of signing a sale agreement and the effect of signing a transfer? In fact, if I may ask, are they the same document? Could there be any difference between these two documents?
Yes, there is a difference between the two documents. The difference comes into play by the process by which you arrive to both documents. When you are talking about a sale agreement, it means that you are engaging yourself, or you're putting up yourself to the contract. It just means that you have contracted the the other party through an offer, acceptance, and now it is now pending now either consideration or maybe there is some deposit that has been deposited pending completion. But when you are talking about the transfer document, it means that certain rights have already been passed, or they have been conveyed to the other party. But you cannot talk about the rights being conveyed to the other party at the sale agreement. Thank you.
Okay, is it possible to sign the two documents together, same date, same time?
It is not possible because as as an advocate for the purchaser, there is a reason why you have to contract into the completion date, because there is the issue of investigations and due diligence that you have to undergo, and before the document can be signed up can be attested, you have to ensure that there are certain things that must be in line. That is, for example, to ensure that you have a good route to the title, there is that stage in between the sale agreement and the transfer. So I don't think if it is possible for you to have the sale agreement and the transfer on the same date.
All right. So next question is a scenario that I'm going to give you. A friend of mine owns a petrol station somewhere in Rongai. The petrol station is under franchise agreement. It's called Lake Oil. Now, this friend of mine is worried that the county government, he received a warning letter last Friday that the county government intends to, kick him out of that land, the space where his petrol station is. He's come to my chambers and he's really, really worried, and he's wondering if I can make this one application, underline application, if I can make this one application to court and have him stay in that particular land where he's built his petrol station unless and until something else is completed. Now, I told him that for that to happen, there are particular elements that he has to meet, or there are things and grounds that he has to prove for him to be able to, have this application made to court and have the right results. I'd just like to ask you, what are these elements? What are these ingredients that this application must meet for us to get something that would help him or cover him in the interim? And what application are we actually making?
My question, I didn't get the first part of your question on where the land is situated. Kindly, if you may.
The land is in Rongai town. He owns a petrol station that is located in Rongai town. He's received a warning from the county government that they intend to chase him away from that land because of a case that they are planning to file in court, or rather they've already filed that particular case in court. Now, he's come to my chambers asking if I can help him, because he has heard that there's an application that if I make, then at least he'll be covered in the interim. Now, my question is, which application is this? And which ingredients must I meet or must he meet to be able to get this thing that will cover him in the interim?
Okay, thank you. Now I can get the gist of the matter. This particular application, in my own opinion, is a judicial review. And under the judicial review, I think I would apply the requirements of a quietimate injunction, whereby because of fear and basically what quietimate talks about is a Latin word meaning because of fear. Now, what I would propose to be the elements is that first thing is that I must have a prima facie case. Number two is that I would risk to have irreparable harm to my ongoing business, because if the government has different plans on my piece of land, then it means that my business will stop running. Number three, I would convince the court that I have a strong case against the government, which on a balance of probability is that I will win that particular case. Thank you.
Okay, welcome. One last question. A friend of mine filed a suit at the small claims court, and he has lost this suit now. He believes that the judge erred in various issues, and he wants to file an appeal. Which court should he file the appeal at?
So first of all, I don't believe that the issue can be handled by a judge. I believe that the issue will be handled by a magistrate, and for that particular reason, I don't think if you can appeal a decision from small claims court. Thank you.
Okay, thank you. That's all, Angelo.
Okay, thank you. Since my colleague has asked you practical question, and due to time factor, I would like to ask as many questions to your other colleagues as possible. My questions then will be straightforward.
Yes.
All right, sir. Please name for me the types of pleas that you know of.
Yes, the type of pleas. The first one is a plea of guilty. The second one is a plea of not guilty. The third one is to remain silent. The fourth one is a plea that the matter has already been heard before. That is outre fois convict or outre fois acquit. Then there is another plea. There is another plea which you tell the court that the court lacks jurisdiction, and there is also I think that's all.
All right. Do you have any authority in mind in terms of pleas?
Yes, I have some authority.
What is the Locus Scholasticus case on pleas?
For example, there is the case of for a plea of murder, whereby, if I can remember, Republic versus Hussein.
Okay, that's fine. Let me ask you another question. Okay.
Yes.
Please distinguish for me these two things, a judgment and sentencing.
Okay, so for sentencing, the difference between judgment and sentencing is that for sentencing, you have to sentencing comes before the judgment. That is the main difference. So that you can have mitigation in between the sentencing and the judgment. The main reason why we have sentencing before judgment is that so that the judge, when he has already meted out the sentencing, for example, you have been already proven guilty during the sentencing period, the judge, when he has retired to his chambers after the mitigation, he can think of a reasonable judgment to give you when the time comes. Thank you.
Okay, then finally, differentiate for me between a decree and an order.
Okay, a decree mainly comes in the form of it comes mostly in the rundown cases whereby you have let's say there is the judgment debtor and the judgment creditor. In between the judgment, you can have a decree say the judge or the magistrate declares that a certain amount is supposed to be paid to the judgment creditor. But when it comes to an order, this is a direction from the court. Either it can be preventive, it can be mandatory, it can be, yes. I think that's all I have to say about it.
Okay, thank you. Daniel, is it okay if I can give my feedback first and then you come?
No problem.
All right. Okay, sir. Thank you for your attempt. You have tried. You have an idea. It is just that maybe kidogo kidogo tu hapa na pale. But we can. That is why we are here. Okay. So I will start with a decree and an order. You see, even if it is not an RTA, even if it is a petition in the Supreme Court, or it is a decision rendered in the High Court, okay? So a decree is extracted from a judgment, whereas an order is extracted from an application, or you say an interim application. For example, that question that was asked by my good friend Daniel Odur. So something that you extract from that application is called an order. Okay, but what you extract from a judgment is called a decree. Okay. Then on the distinction between a judgment and sentencing, for me, I would go with simpler definitions. For example, judgment means an adjudication by the court in that a defendant or an accused person is guilty or not guilty. So that particular adjudication that will come to the conclusion that an accused person is guilty or not guilty, that one is a judgment. Whereas now sentencing, on the other hand, you see, it is another thing altogether. It is different in the sense that it is a procedure at which a particular court of law of competent jurisdiction makes an order on the specific penalty to be meted out on the accused person. Okay? So it is a process at which now the judge is going to say your penalty is this and this. So if they are saying that you will be sentenced to death, then that is your penalty. Life imprisonment, or is it 30 years, or is it 2 days, then that is sentencing. Then on that other end, the question that I asked you before, please, you named all of them well. Okay, I cannot add anything on that. Except where you, jurisdiction is there. Okay, so plea of not guilty, plea of guilty, plea of ultra voice, acquit or convict, double jeopardy, pardon. You can keep mum. You have really you did well there. However, you cannot talk about pleas without talking about Adan versus Republic. That was the authority I was looking for. I hear you say that a plea of murder. There is no plea of murder. Okay, so you have named all the pleas well, but now go back and read. It is really common in bar examinations and even in your orals. So go and read the case of Adan versus Republic. Nevertheless, you have really done well, and keep going. Thank you, Daniel.
Thank you so much, Angelo. I think that was really quite a good and comprehensive feedback. I won't take a very long time, but I think maybe I asked you very easy questions, and I think to some extent you really got a hack of probably all of them. Apart from the last question that I asked you, you can't say that there's a court that you can go to and get a judgment and you can't appeal. It's only in arbitration clauses where you can add that, whatever you'll get from arbitration is the final, decision. And really, there's nothing else you can do. So I believe that any decision of the small claims court can be appealed. And where you're supposed to go to is the High Court. Yeah, the reason why I asked you that is because I thought maybe you'd say the magistrate court and things like that. So yeah, appeals from the subordinate courts go to the High Court. Did I ask you anything else that maybe I'd like you to? So Moto, yeah, you got that right. The court decided to do it voluntarily. It's on its own motion. Without someone making a particular application. I think that's all. The other questions, yeah, it was an interlocutory application and injunction, and I think you answered well. I don't know. You talked about balance of probability, and I don't know what that meant. Yeah, but maybe it means balance of convenience. I don't know. Maybe it depends on you. Yeah. So I also thought maybe you'd talk about Jailer versus Kaufman Brown, but that's okay. You don't really have to say that. But yeah, we have prima facie case, irreparable damages, then balance of convenience. Then nowadays people also talk about public interest. I've seen people talking about that in other cases as the fourth element. You can just look into it and let me know what you think probably in our next discussions, or maybe in the group you can always post and let us know what you think. But I think you got a hack of most of the questions that I asked you, and I think you did well, and your presentation was good. You are composed, you're clear. I was able to hear what you're saying. Now, in relation to oral exams, I mean, it comes from the word oral. It's done, it's orally. So basically what really matters is, yes, of course, it's very important that you know what you're saying, but we also want to see how you present what you know, basically. Because again, someone will tell you, it doesn't really matter what you know. If you can't let me know what you know, then, there's no effect. I want to know what you know anyway. So we just want to know what you know really. And for us to know that, then you really have to tell us what you know. And so it's very important that we have these exams. So that you see, if one day you're in court, how would you let the court know, what your case is about, why your client is there, why you think your client is right and not wrong. So yeah, it's very important that apart from talking about the knowledge that you have, it's very important that you talk about the fact that, the lecturers are trying to interrogate and see if you know how to present orally by word of mouth, verbally, what you actually know and what your case is about. Yes. So that's all I can say, Wekesa. I wish you all the best, man. Keep doing your best, keep moving, keep putting in the hard work. Please try to know a bit of everything and you'll be good, man. You'll be good. Congratulations and good work. I think we can go to the next person. And yeah, we said the next person we'll have Donna. If you're there, you can do it with the limb. Then I think we'll have Osumba and Angelo.
Yes,
Angelo, I see you are unmuted. You want to...
just to correct, I heard him say something about judicial review. I don't know if I had it wrongly.
Oh yeah, true. Yeah, true.
But
That is
perhaps
also...
you can comment on that.
I think that was misdirected. I think we have a judicial review when there's a decision that was made. Now, I told you there was a case in court. These guys have filed a case in court, but even before it's over, they want to remove him from that particular land. So a decision really hasn't been made yet. You see, where you're saying, when you're talking about a judicial review, is they're coming to you and, there's always they sat down, they did this, and they made a decision. So it's an application that you're making to the court directly. You are making an application to the court directly so that you can get a particular, order that will cover you in the interim as fast as now. Then, if you are filing a case for judicial review, I mean, these things take long to have a decision. The court will take a long time. We have to go through the whole process of, proceedings and everything else. I mean, by the time it's over and you get your judgment, you are out. You've been out there for 3 years, out in the cold. The court is just telling these guys that, oh, you made this decision and it's wrong. And now this guy really actually needs to get back his land. So I don't think that was the right way to answer it. But yeah, an interlocutory application would have worked so that you get the orders that Angelo was talking about. Angelo?
That's fine. That's all right. Our next volunteer is someone called Cheptengat or Cheptelat, I don't know. His hand is down. He was supposed to come next. Then we will have these people. We have Wanjiru and then Tum in that order.
Okay, so Donna, you're there. You can just unmute.
Excuse me, Kidogo, can I ask a question?
Yes, a quick one.
I didn't really raise my question so that I can volunteer, but I wanted a clarification on the first person who answered questions. There's a question that was asked, which is the smallest court of the land, and she answered the small claims. So I have a question because doesn't the small claims fall under the same category as the rest of the magistrate courts? So I'm just seeking clarity on why it is the smallest court of the land.
Okay. Osumba, would you like to? I think it handles the smallest claims that someone can have. And, I mean, it doesn't go lower than that. But anyway, Osumba, I think you're the one who asked the question and answered it. Maybe you can address it.
In terms of pecuniary jurisdiction, it is the smallest because it handles claims that are below 1 million really. So that's why it is the smallest court in the land. And ideally, the people, the judicial officers who preside over it are called adjudicators. So there are adjudicators of magistrates.
All right, thank you so much.
Thanks, Tum. Yes, Donna, are you there? Ama Angelo, she's not in.
I thought she was. Yeah, so we have
she's in.
Cheptangat. Eh?
Okay, so Donna, you can go ahead. You and Lim.
Good evening. Am I audible?
Yeah, loud and clear.
Okay, thank you. Cheptangat, good evening. Cheptangat, Levi or Levi.
I think she's muted. Maybe she needs to unmute. Donna, maybe you can text someone else.
Yeah, that will be okay.
Okay, Angelo, you said who was next on the list?
It was 1-0. 1-0, you can unmute. Wanjiru, your hand was up.
Good evening, ladies and gentlemen. I think I just wanted to ask a question. I hope the panel can allow me to ask the question.
Can we please have the questions at the tail end so that we've only done 2. 1-0, if you don't mind. However, we can take you on for
all right.
For yeah, we don't mind taking you on for.
No.
Do you mind?
I mind because I wasn't prepared to have myself interviewed at this moment. Maybe I can. This is my first moment to be here, my first meeting. Maybe I wanted to ask a question, but let me ask at the tail end, as you say.
Okay, and just post it in the chats so that we'll just go through them quickly at the end.
Oh, all right.
Yeah, all right. Angelo, maybe you can get us someone else. I think we have Mwangi Masi.
Tum. All right.
Mwangi, kindly unmute.
Good evening.
Good evening. How are you?
I'm fine, thank you. I hope you are fine too.
Well, so welcome to this session. I'll just ask you a few questions. Don't be nervous. Yeah, very easy questions. Okay, my first question. Your uncle intends to purchase some property in Kitengela, but he has gotten some emergency. He's supposed to travel abroad and will not be able to undertake that transaction on time since they had agreed to do that on at an agreed period of time, which he's supposed to be traveling. So he wants you to undertake that transaction on his behalf. What is the document that your uncle will need to have to allow you to undertake this transaction on his behalf?
Thank you, Donna, for that question. I think it will be the power of attorney document.
Yeah, that's correct. So how many types of power of attorney do you know?
I honestly don't know any.
Okay, and is this document registered?
Yes, I think you have to register it first.
Okay, and what are the circumstances in which you can revoke this power, in which your uncle can revoke this power of attorney, or even you can revoke the power of attorney?
So I think some of the circumstances that one can use to revoke the power of attorney, for instance, if the uncle now has come back to Kenya, he can revoke the power of attorney. Also, assuming he's able to cite that at the time of granting that power of attorney, probably he was not mentally okay. And also I can at any point I can revoke that document.
That was good. So another question: you're conducting a civil education in view of the recent circumstances around the country. So in your village where you come from, you together with a group of other youth have decided, let's educate our people. So you're telling them about the rights of an arrested person. Under which article of the Constitution is this right provided?
So thank you for the question. Article 49 of the Constitution is the one that provides for the rights of an arrested person.
So can you tell your villagers 5 rights of an arrested person? Just 5.
Okay. Some of the rights of an accused person include, first of all, this person has the right to be informed of his right to remain silent, his right to be informed. There's also the right to be informed of why he has been arrested in a way that he understands, or rather in the language that he understands. Also, he has the right to be kept separate from those already serving a sentence. He also has the right to be presented in court within 24 hours, or if 24 hours are outside the ordinary court hours, the soonest time possible. Yeah, I think that's the much I can say.
Yeah, that was very well. That was very well. The question: what's your duty as an advocate? What's your duty to your opposing counsel? Assume you're in court or handling something with the counsel towards other.
Is it okay if you come again?
Okay, so you have been admitted as an advocate at Mwangi.
Yeah.
So what duty do you owe to opposing advocate, or just the other advocate generally in the profession?
So thank you. One of the duties I'll owe them is the duty to remain courteous. Also, I'll owe them the duty, for instance, I know that this advocate is maybe coming from a far place, and probably I want to tell the court probably to adjourn the matter. I don't know the specific duty, but I have to tell them to not come in the first place. Also, I owe them the duty not to harass them and to assist them when they need my help in regards to the issues of probably law or something.
Thank you. Anyangu, could you mute your mic, please? Anyangu, thank you. And the last question, Ms. Mwangi, what are the conditions? How do I put it? What will make an oral will valid?
Oh, so thank you for the question. So an oral will, for it to be valid, first of all, it has to be made like 3 months prior to the date of this person dying. Also, it has to have 2 witnesses, who are competent. I think that's it.
Thank you. That was a very good one. Kimlim, you're next. Thank you, Mwangi.
Thank you so much, Donna.
Yes, Mercy. How are you?
I'm fine, thank you. I hope you're
You
fine.
are doing well. Yeah, you are doing well. And I'm just going to build up from what my colleague has asked you. And I'm sure you are aware of what is happening in the country currently.
Yes.
Yeah. What is that is happening in the country?
Okay. So what is happening in the country? I would say that people are exercising their constitutional rights to assemble. I mean, to go do demonstrations out there because of the things they feel that the government is not doing.
Where do they drive that authority when they are exercising their rights and all that? Where do they? What is the basis of their? What is their basis?
I will say this: first of all, the authority, they derive it directly like from the constitution. So unfortunately, I'm not so sure about which constitutional article.
All right, fair enough. That's okay. You're on the right track. They are driving it from the constitution. Have you ever heard of Article 1? Do you know what it says?
Article 1 of the Constitution.
Yeah.
So, okay, the Article 1, it states that the Constitution is the supreme law of the land. But I think it's supremacy of the Constitution, if I'm not wrong.
All right. Okay, fine. Maybe you'll have to refresh once you leave here. But you're doing well. Now, can you tell us the difference between revision and review? Those 2 terms, have you heard of them?
Yes. So by review, do you mean the judicial review?
No, just the term review and revision. They are 2 terms that are common in law.
Let me attempt. So for review, in most cases, it's whereby you are asking the same court to review its decision. So for instance, a decision has already been concluded, but now there's new and compelling evidence that at the time of holding that trial, you could not access it, but now it has come into your possession. So you ask the same court for review. So for revision, in my opinion, I feel it's now the High Court that is going through the trial, like the trial entries that were made during the proceedings at the at the trial courts.
Sorry, what have you said of trial? Sorry.
Oh, sorry. Okay, I was saying for revision, it's whereby now the High Court, it's not like really like, it's not an appeal, but the High Court is now like looking at for instance, like what evidence was tendered, like the trial documents that were tendered, the entries and everything.
Okay. Now, you following on the current events and a number of your colleagues, I want to presume that you are a Gen Z. A number of your colleagues have been taken into custody by the police, many of them, and then they have been charged at the magistrate court, and the charge is a charge of treason. What will you do as an advocate of the High Court of Kenya and a member of LSK, which is playing a very active role in that?
I think the magistrate court has no jurisdiction to hear treason matters. I think it's only like from the High Court. So I will make an application, probably for a preliminary objection, citing the court that it has no jurisdiction to hear that matter.
All right, you're doing well. Now, using that example, what powers will the High Court be exercising in that regard? Based on the two terms that I had asked you about the difference.
So in accordance with Article 165, the High Court will be exercising its supervision powers.
Supervisory powers.
Yes, yes.
All right, yes, I agree with you. But I wanted to limit you on the two terms. Okay, I asked you to give me the difference between revision and review. So in such a case, I agree it is the supervisory power. But if you are to narrow it down and pigeonhole it in the two terms that we started with, where will that exercise of supervisory power fall? Mercy, you are
I
doing
don't
well.
have anything on top of my mind. Sorry?
You are doing well.
So, I honestly don't have anything on top of my mind in regards to that.
All right, all right. Perfect. Thank you so much. We will leave it there now. Yeah, thank you.
Yeah,
I don't know
thank
whether
you.
Donna can give the feedback first or
That will be okay. Lim.
all right.
So Mwangi, that was very good, very, very good. You have good composure in life.
Thank
And
you.
keep up with the spirit, keep practicing. I think I asked pretty easy questions and you're able to get all of them. Where you're not sure, for example, the power of attorney, you can just go back and read and know the form in which it should be. Yeah, so that's it. I really don't have much to say. You did very, very well.
Thank you for that.
Okay, thanks.
Oh, unless you on any question that I had asked.
So, okay, maybe just to inquire about whether the power of attorney document is registered.
Yes, it's actually supposed to be registered with the lands. I can't really recall, but just go and it was a question I was asked in my orals. I read and forgot afterwards. But yeah, it is supposed to be registered and it is lodged to the lands registry. It's supposed to be in a particular form. I think I can't remember, but it's under the LN 278, legal notice 278, which has the form. So you'll just find the form there and it's supposed to be registered with the land. Yeah, and even the revocation is done in a particular form. You do a notice and then you take it to the registrar saying that you've revoked the power of attorney.
Thank you so much for that.
Yeah, Mercy, you did well, and just be audible and confident. You have the content. The one when I was telling you about Mandamano and all that, you cited. I told you to if you can remember which article, and you cited Article 2. But the correct article is Article 1, because when you are doing Mandamano or protest, you are exercising your powers directly. Powers belongs to the people. Yeah, sovereign powers belongs to the people, and the organs of government do exercise it indirectly. You have delegated it. So when you go to the street, you are exercising your powers directly. I thought you could also bring out Article 37, the exercise of the enjoyment of political rights. Those are the things that I wanted from you, but you just explained it, and that is okay. You just need to have that confidence. And if you have the law, I want to emphasize, because it really helped me when during the time of the orals, when I was asked a question and I see it is related to a certain rule or the legal provisions, I will start with that, and then I explain it. I'll say that fact relates to this section of the law or this article of the law, and they were really mesmerized, and you gained their confidence. For me, I gained their confidence through that, and they couldn't believe even when I was unable to answer the question, they would tell me, you know it is only that you know it, and that is something that they really liked, because I started and they said I was so specific. So I don't know whether that is unique to that panel, but it is something that you can borrow. If you can remember the law, just start with the law and then relate those facts to the law. If you can't remember, just do say what you know and you leave it there. So I wanted the article. I think you the fact that you referred to Article 2, for me, you can just enhance it, continue preparing, you're doing well. The other thing I was asking about revision and review. You are right. The way you explained it, revision is a supervisory power, and it is exercised by an higher court, a court that is higher. And actually, when you said, I used the word, the people have been charged with the treason, and you pointed out the question of jurisdiction. And that question of jurisdiction is actually a ground for you to ask for revision. And where will you ask for revision? You ask it at the High Court. It's the High Court that has that jurisdiction. So even when I was telling you to pigeonhole, I was actually trying to lead you towards that. And these are some of the things that they normally do. And it is good that you said you can't, because even that thing happened to me. They tried to lead me to something, and at that time when the tension is there, you're like, no, my mind cannot reconnect it, and you just say it and it is okay. But once you get their confidence, even when you say that, normally they are relaxed because you have already gained their confidence. So revision is exercised by a superior court, and most of the time, actually, it is only the High Court that exercises it, and it exercises it over the magistrates. It reviews the the decisions of administrative bodies. You can see the example now of, you remember there is, I think currently there is that question of the banning of by the judges of the Supreme Court of Abdullahi not to appear before them. And people have gone to the High Court, and the High Court has ruled that it has that power to look at that administrative decision of the Supreme Court. So I mean that is it. And then the question of review is, it can be done by any court, as long as there is an error apparent that is there, just a mistake that is so glaring, prima facie, you look at it, then you can actually call the same court and ask them to review their decisions. Yeah. So again, when there is you pointed out the discovery of a new and important matter or evidence, I mean, those are grounds that are, but the difference is that when it comes to revision, it's the power of the High Court. When it comes to review, it can be exercised by any court, and the grounds are different. You look at the grounds for the question of jurisdiction, failure to illegal or irregular exercise, that will call for review. When it is a question of apparent mistakes, discovery of new and material evidence, it's a question of review. I think those are the two questions that I asked you, unless there is any other that I have left, you can raise it. Otherwise, you did well. Keep on revising. You will has it. Yeah, thank you.
Thank you so much.
Over to you, Daniel or Angelo.
Okay, thank you. Angelo, maybe you and Osumba can take on the next person.
All right. Osumba, maybe you can go first, then I will come.
That's okay. Who's available?
We have Tum.
Good evening, Tum. How are you? Hello. I can't hear anybody.
Good evening. Aki, I'm so freaked out. I don't know if I'm ready for this.
No, it's okay. I mean, it's fine. Believe you me, you're more than ready. And that is why we are doing this. Because actually, this thing it serves two purposes. Sorry. One, preparing you for your oral exams, but also for pupillage, because soon you guys will be sending out your CVs, looking out for pupillage places. And whether you want or not, you're gonna be asked questions, and there'll be questions to test your knowledge of the law and how to now apply what you have learned in class to real life situations and provide solutions. So you're good. I'll ask you only 3 questions, very easy ones, and you'll be okay. Are you ready?
Right, let me try, because at the end of the day, we must always start from somewhere.
Very good. I like that. Now, this is the afternoon session. Kindly introduce yourself.
Good afternoon, Mr. Okeyo. My name is Tum Joy, a member of Class E, Farm 2.
Very well. Now, under Section 55 of the Advocates Act, an advocate is deemed to be an officer of the court. And as an officer of the court, an advocate has certain duties to the court. Would you tell us what duties of an advocate to the court?
Sorry, you're breaking.
I'm saying, would you tell us 4 duties of an advocate to the court? Because under Section 55 of the Advocates Act, an advocate is considered to be an officer of the court. So as an officer of the court, what are some of your duties to the court?
All right, an advocate is an officer of the court, and some of the duties that he or she owes the court is the duty not to mislead the court, the duty
Yes, you may proceed. You're actually right. I agree with you. One of them is not to mislead the courts. And 3 more and you're good. You're muted. Hi, are you there?
She's muted, Trum. If you are speaking, you are muted.
So I think Tum as I think she's scared. But guys, that's why we're here. I mean, you can imagine what would happen now if it were now like the real oral situation. So just be confident enough, and you'll be good. Some of the duties of an advocate to the court, of course, as she has said, the duty not to mislead the court, the duty to administration of justice, the duty to, courtesy to the court. And then there is also the aspect of keeping time. You should not be seen to be wasting the time of the court. So you'll always be advised that it's prudent you arrive before the court starts. That's okay from me.
I don't know. I don't know if Tum is willing to proceed, but under the circumstances, maybe not. Or Tum, would you be willing to proceed? All the same, it's okay. As Usumba have said, this is why we are here. And we are here to encourage each other to be better, to do better, and at least as we continue to have these sessions, you get that confidence. One day at a time, one day at a time. It's a work that might take time, but we are hoping that by the end of the day, when we're done with this, you'll be confident enough, at least better than now, and you'll be able to just go through this. It's not the end of the world, and it's okay. It's possible. It's possible. So, Angelo, I don't know. Can we get someone else, Angelo?
Yes, we have someone else. His name is, her name, Muendo. Please, you can unmute.
So maybe I'm thinking you go first, then you allow Osumba to go after you.
Okay.
Maybe its questions are too hard.
All right. Your name again, please?
Am I audible?
Yes,
Good
you are.
evening.
Can you hear me?
Yes, I can clearly hear you. Thank you.
All right. Let's assume your session is in the morning. Good morning. Kindly introduce yourself.
Good morning to you, Mr. Angelo. My name is Mwendo Sharon Waiwa. Currently doing the Advocates Trainee Program in Kenya School of Law, admission number 2024-0421 in Class F, Farm 20. Thank you.
Very well. Now, there's something here I would like you to guide me. Over the last couple of weeks, you have been saying inject, you have been saying reject finance bill. So you don't want to amend, you mean reject, and then I don't want to comment on the other. So now your maandamano has apparently been infiltrated by goons, but now rumors were now going on that they were paid by some people from central Kenya, from Nairobi, from where. But now you have come to realize, of course, I'm not supposed to be quoted, but there are some allegations that uh, there are some politicians from central Kenya. But now you have threatened the life of the Deputy President of the Republic of Kenya. Can you please maybe tell me, you have made a threat against the life of the Deputy President. Can you be charged with treason? I know people have been called, they have been called terrorists, treasoners, but now specifically for this one, can you be charged with treason?
Thank you. Thank you for that. I don't think you might be charged for treason on grounds that the president he had previously announced that he will not sign the finance bill, and since the withdrawal of the bill, there's still calls that he will resign and the rejection. So I don't think he'll be charged with treason because there is no evidence to support those claims, because you were doing peaceful protest and you have freedom according to the constitution. You have freedom for expression and how you articulate your concerns.
Okay, thank you. Can you please maybe tell me, under Section 40 of the Penal Code, what is your understanding of the offense of treason?
Okay. Section 40 of the Penal Code. I know treason is committed when a person imagines or intends the death or wounding or imprisonment or restraint. So treason is basically committed by levying war against Kenya or supporting the enemies of the Republic or instigating an armed invasion in Kenya. So it can be committed by anyone who owes allegiance to Kenya, and including citizens, residents, and foreigners, basically within the Kenya borders, who enjoys the state's protection. So I know the penalty for treason is mandatory death upon conviction and is tried exclusively by the High Court. Thank you.
Can anyone be charged with treason against any person in the Republic of Kenya?
Looking at that, I remember the case of Miguna Miguna, where he was deported because he was charged. He treasoned. Sorry, let me catch my breath.
All right. Thank you.
Yes.
Thank you. You are doing well. You are doing well. If you have juice, you can sip it. No problem. Another short question: what is the jurisdiction of the Supreme Court of Kenya in criminal matters?
Jurisdiction, no?
Of the Supreme Court of Kenya, what is the jurisdiction of the Supreme Court of Kenya in criminal matters?
In criminal matters.
Yes.
So the jurisdiction of the High Court of Kenya, this is provided.
The Supreme Court. The
Supreme
Court of Kenya. In criminal matters.
Okay. So the Supreme Court basically has exclusive original jurisdiction to hear and determine questions that relate to the validity of criminal matters. And it also has appellate jurisdiction to hear appeals from the Court of Appeal as of right in case of anyone involving the interpretation or application of the Constitution and the criminal matters in that regard. So it further it's basically outlines the jurisdiction and its role as the final custodian of interpreting the process of how the criminal matters are adjudicated. So it can have exclusive it can have appellate jurisdiction from the Court of Appeal, and it can also have original jurisdiction to try the specific matter.
Okay. Thank you for that. Finally, can a non-Muslim child or wife inherit from the estate of a deceased Muslim in Kenya?
Can a Muslim charge?
No, mutoto, child.
Oh.
And or wife inherit from the estate of a deceased Muslim in Kenya?
Yes, they can. Because
please elaborate.
Yes, they can, based on because children basically are the primary heirs of the under the Islamic inheritance rules. So I've read the Quran once or twice because it specifically outlines that the shares for male and for the female children. Now for the children, the general rule is that a son inherits a share equal to that of two of the daughters. So if there are multiple daughters now, in regards to if there's a son, they collectively inherit 2/3 of the estate, and if there's only one daughter, she can inherit the property, the inheritance half. So that's on biological children, and also illegitimate children can also inherit from the mother's side, but not on the father's side. And I'm not sure of the law. I think it's a Hanafi law. So, but the Shai law, it also outlines that illegitimate children basically cannot inherit from either parent. Also, raising the question of adopted children, which are not considered legal heirs under the Islamic law and have no inheritance rights, even if the deceased wanted them to have a share. Yes.
Okay, thank you. I will now yield the floor to my learned friend to ask you a few questions.
Say hi.
Hello.
Hello, hi. Who was on the floor? Sharon. So I'll ask just two questions, quick ones. What are you currently doing in conveyancing? Which topic have you covered?
Right now, the last class we were doing leases.
You were doing leases.
Yes, correct.
I presume you have done leases and licenses because they usually go together.
No, we were looking at the document.
Okay.
Yes.
All right, it's okay. Then yeah, that is okay. There is something called due diligence. Might you be aware of it?
I'm aware of due diligence.
Then can you tell me the stages or the steps of due diligence?
Okay. In due diligence, the due diligence basically refers to investigation of title and encumbrances. which is basically evaluating the risks that are prudent to that. So the steps are reviewing the searches. There are 3 steps: requisitions and the pre-contract inquiries. So requisitions, they are basically the questions asked to the vendor or the holder of the title, and it basically gives out the warranties and conditions. So when the second step in doing the search, there are various steps in search, which includes a historical search, which is conducting the historical aspects about the land, and also inquiring about all the land history. There's also pre-contract inquiries where you uncover illicit aspects that are not covered in the basic searches. And also there's yes, there's also the did I mention the pre-contract? We basically visit the land physically. So due diligence basically involves the searches, the requisition, and the pre-contract stage.
That's okay. I thought you would mention talking to a local drunkard, but that's okay. I mean that's really fine. You nailed it. There are 2 recent decisions from the Supreme Court that really touched on the issue of due diligence. I'm not going to ask you to discuss them, but I'm just asking, might you be aware of it, of those 2 decisions?
Yeah, in due diligence, the 2 cases. I'm not sure of the
Yes,
cases. Is it the Dolo versus Anaj?
I know that, but that was by the Court of Appeal, and I think it was pertaining to the capacity of an advocate to draw conveyancing documents. The decisions that I'm looking for, you want to try?
Yes, there's one I have
Yes,
in
by all-
mind. Samuel Kamere versus the land registrar, which basically provided the threshold for consideration of a bona fide purchaser for value without notice.
All right, that's okay. Perhaps Angelo may want to. Do I give my comments first, or you proceed?
For the
Okay.
yeah, you can proceed.
Yes. Please proceed, Osumba. Give your comments.
It's okay.
Then I will.
It's okay, bro. Sharon, you have done really well.
Yes.
You have a good grasp of legal concepts. From how you sound, you're very confident, and I'm sure you'll do well. The due diligence question, you answered that pretty well. I'm satisfied with the answers you gave. The issue about a local ranker, that's just a joke. When you get to the practice world and you become a property practitioner, you'll hear it a lot. The decisions that I was looking for from the Supreme Court has to be the Torino Enterprises case, and then Dinner Management case, Dinner Management Limited versus the County Government of Mombasa. Maybe just a brief is that the Supreme Court indicated that if the very first title was fraudulently acquired, then every other transaction emanating from that title is null and void. So basically, those 2 decisions underscored the need for proper due diligence, so that then it is no longer sufficient just to conduct a search at the land registry to ascertain the most recent proprietor of the property. You have to I believe if you're being taught by Kegwatha, I believe she has talked to you guys about historical research that will then tell you the history of that property, from the very first owner up to the current one. So those decisions underscored the need for proper due diligence. You did well, and I am certain that you're gonna ace those exams. Thanks.
All right, all right. Thank you, Osumba. Sharon, you did well. In your answers, you give more than anticipated, but it is fine. To whom the more is given or taken, more is expected. I don't know, but well, you'll just fill it in. Okay. You are confident in your answers. You are composed, and that is what they need most of the time. And again, when you see a panelist trying to repeat a question one after the other, so it means that the examiner is looking for something. Specifically, the reason I brought DP in this particular question, it is whether you can distinguish between the president and the deputy president. And that is why I even went to the extent saying if that offense can be committed against any person in the Republic of Kenya. So even when you gave your definitions, well, margins, invents, device, or intents, maiming, wounding, or the imprisonment or restraint, you say everything, but you have really refused to give me that the offense can be committed against the president. So it means that under section 40 of the penal code, if you threaten the life, let's say, of the DP, you injure him, you maim him, you are not going to be charged with treason because he is not the president of the Republic of Kenya. So I was really squeezing you such that I can see the reason I brought DP in and not the president. It is such that you can tell me the actors' rules. Okay, the actors' rules must be directed at the president of the Republic of Kenya. Okay, under section 40. So anyone else who is not the president of Kenya, it doesn't matter the office that you hold. Okay, so the normal penal code, the offenses within that have been prescribed in law in Kenya will apply in case, let's say, you threaten the life of the deputy president of the Republic of Kenya. So I was specifically looking for that. On the aspect of the jurisdiction of the Supreme Court of Kenya in criminal matters, you have done well. You have highlighted the jurisdiction, election petition, the appellate, but I was very specific on the aspect of criminal matters. Yes, you have mentioned it, but I wanted you to tell me that under Article 163, the Supreme Court of Kenya has appellate jurisdiction over criminal matters originating from the Court of Appeal. Okay, that is on pure points of law of significant public interest. Okay. By the way, basically, the litigation in criminal matters ends at the Court of Appeal. So unless now, if the matter has been certified, maybe it is a matter of public interest, okay, or it has that aspect of, like, let's say, for example, the Muratetu case, there has been certification that have been made in criminal matters to the Supreme Court. Even recently, Justice Odunga and his colleague from the Court of Appeal in Mombasa, they refused because they wanted to interrogate whether the rights to appeal of a person that is accused of murder that will not enjoy like same, let's say, maybe someone who started litigation at the magistrate court, so that person can actually appeal even to the Supreme Court, but maybe someone in high court, like your appeal mechanism are limited, but they refuse that one. They say that one, it is not a matter of general public importance, and it was never certified, you see. So I wanted you to tell me on that, like that or somehow, but you really answered well. Then finally, it is on the aspect of whether a non-Muslim child or wife can inherit from the estate of a deceased Muslim in Kenya. The straight answer is that no, they cannot. But it is not simple as saying that no, they cannot. I know you said yes, and you see your arguments were actually right. Okay? You cannot, because the constitution is very clear. By the way, the constitution does not discriminate. The Sharia law, yeah, it is straight. They cannot. Okay? You can look at the case of the re-estate of CCBH. That one was decided in 2017. You can juxtapose that decision with the case of Chelenga versus Juma. Okay?
Yes.
But with this constitutional dispensation, it is really hard for you to argue that a non-Muslim child or a wife cannot inherit from the estate of a deceased Muslim in Kenya. So now you bring in the aspect of Article 27, okay? You bring in the aspect of, is it Article 53 yenye inadili na watoto ni gani? You look at those articles such that you can defeat an argument that an illegitimate child to a Muslim cannot inherit from the estate. So some people are asking CCBH, re-estate of CCBH 2017. CCBH 2017. Okay. You also juxtapose it with the decision in Chelanga versus Juma. Maybe, and then now look at the recent decision, because this is something that has been litigated in Kenya. So now look at it in that aspect. So yes, CCBH, someone, yes, 2017. All right. Thank you. Daniel, maybe you can take it away.
Thank you, sir. I think that was nice. That was a good session. Yeah, just something that maybe I've noted and maybe I'd like to talk about is I've found it so easy to always say, I think. Daniel, what's the answer to this? I think the right provision should be, and it's an easy way out. It's an easy way out for lawyers. But I'd just like to advise when it comes to orals, let us try our best not to use the word I think, because if you are telling the lecturer that you think, it means you're not sure. The way I think Angelo said earlier, when you're giving your answers, give your answer. Don't say you think, because if you tell me you think, then it's an opinion. It's not the right answer. So if they tell you someone came to your chambers asking for this, and this, please go straight to the answer. If you have no idea, then, that is another story. If you want to attempt, I think it would be okay to make it clear that you don't know the right answer, but you can give it an attempt. You can try to answer the question. Again, I know sometimes it's safe to play safe. Again, don't find yourself starting all the answers with, I do not know the right questions, but the right answer, but allow me to attempt. Okay? So just use it when you think. You see that time you think, that is when you need to say, I don't know the right answer to the question, but let me attempt to answer that particular question. But when you say you think, then it means you're giving your opinion. So maybe it's such an easy way out. We do it sometimes all the time without even noticing. I think the answer is, but every time you start a statement with I think, it means that is not the answer. That is your opinion. Okay? So every time you think about saying I think, say, let me attempt to answer the question. Angelo, is that a problem?
No, there's no problem. I just wanted to add, I have also heard people saying, I believe. So when you believe, so it actually becomes an opinion. Okay? So you don't need to believe. You just give your answer, believe in yourself. And if you don't, just follow like what Daniel said. So don't say that you believe. That is it, Daniel. And we have one person that has raised his hand. So that is continue, Daniel.
Yeah, thank you. Yeah, so try not to use those words. Try not to use I believe or I think. I believe or I think. Now, we only have one person. We are trying to maybe be done by 10:30. Because Dave
Did
started at
someone call
9.
Kenyanjui? Yeah, I don't know
Yes,
if I see
Kinyanjui?
it right. Yes,
Donna,
just
are you
lowered
in?
his hand.
Maybe you can take this with you. Donna, are you in?
Yes, I'm in.
Donna, are you still there? Okay, so maybe you can do this one with you. I'll start. Kinyanjui, are you there? Okay, if Kinyanjui is not ready, can we maybe get someone else? Anyone else? We have, Levi, you want to go again? Or you had
Yeah,
an issue last time?
yes. My network dropped down, and I'm really sorry. I really wanted to do it. Nimesikia vibaya sana.
It's okay. Now here is your time. Mhm.
Redeem yourself.
So, redeem yourself, yeah. And you're lucky to find me. I don't have hard questions like some of these guys. Sawa, Levi. Yeah. So maybe you can introduce yourself. Then again, sorry, Levi, before you do that, please try not to say my names are. Okay. My name is Daniel Stephen Odur. Just say what your name is.
Okay.
Don't say your names. Yeah. Go ahead. Kindly introduce yourself.
Okay, my name is Levi Cheptangat. I'm a student at the Kenya School of Law, plus F from 12, and I'm here for the oral exams. Hoping to do well and to learn also from you. Thank you.
Thank you. Thank you so much. Thank you so much, Levi. Levi, I have a few questions today, and my first question is just to get your opinion on this matter. Recently, we've had a lot of protests in Kenya. They've been termed Gen Z protests. I'd just like to know, what is your opinion on having these protests? What is your opinion?
I think now I can use the word I think because my opinion. I think
Yes,
the Gen Zs are just using their constitutional right. They're exercising their constitutional right as provided by Article 37 of the Constitution, and they're also showing that power belongs to the people. Sovereign power belongs to the people, and if the people are not satisfied by the decisions of people who have been elected to exercise the power indirectly, then people can exercise the power on their own. So that is my opinion.
Okay, so some of my friends were arrested during these protests, and they were asking me how I could help them. Just to confirm to you, they received help, they were helped, and now they are out. But to help them, what do you think I had to do in that scenario?
First of all, you bailed them out. You went to the police station and you bailed them out. And then another thing that you probably did, you went to the police station and asked the officer in charge the reason for the arrest. Because if you arrest someone, you need to explain to them the reason for the arrest. So if they did not have any reasons for the arrest, then they're supposed to be released. Yes, that's what I can say for now.
That's okay. Now, all right. Now I have a. So you're saying I bailed them out? I just went to the police station and bailed them out. Okay, that's fine. Now you've used the word bail, the term bail. What are the different types of bail that you know of? And before you answer that question, I have another question. Now, one of those friends that I am talking about, one of them was actually, the police looked for him but did not find him at all. But the intention is to arrest him. Now, you've used the term bail. He's wondering which type of bail should I pay for him now that I pay bills?
I think because you are anticipating arrest, you'll use anticipatory bail. anticipatory bail. I can't really recall all the types of bail right now. I don't know. I know them, but I can't recall them right now. But I can remember the anticipatory bail.
Okay. And the right to bail, where is it in the Constitution?
It is provided under Article 50. I don't know the exact article, the exact clause, sabbatical, but I know it is under Article 50. And this changed. Okay, this changed everything. Like Kitambo, they never used to give bail to every offense, but now everybody is entitled to bail unless there are compelling reasons not to give out bail.
Okay, that's fine. Now on that one, I'd just like you after this session, maybe you relook at your constitution again, because Article 50 is on the right to fair hearing, but that's okay. That's okay. That's okay. I think sometimes,
Okay.
yeah, we can get confused in life. Yes.
Okay, sorry.
It's okay. It's okay. That's fine. That's fine. So I'll go to the next question, which will also be very quick. A friend of mine came to my chambers informing me that they had applied for a review. Now, I've heard during this session that a review is applied for in the same court that made the decision. And I think the instances where you can apply for this particular review have been well explained in this session. Now, he applied for the review, but the decision was again against him. He felt like the judge erred on several issues. He wants to appeal. Do you think he can appeal?
Yes. After the review, you can still appeal. I believe you can still appeal.
Okay, so you can apply for a review, have the case reviewed. If you don't like the decision of the court, you can appeal. That is your position.
Yes, I believe so.
You believe so, or that is the position?
That is the position.
Okay, sawa. Yeah, I keep saying that just to nail it into your name so that you can always remember. Anyway, yeah, I'll go to my last question. Then I think I will proceed from there. This is very simple. What are completion documents?
These are documents that are handed over from the vendor from the vendor to the purchaser that gives rights, the interest, that transfers the interest of the property to the purchaser. Yes, that's what I can say for now.
Okay, so there's a friend of mine who was supposed to deliver this completion documents after 90 days, but on the 90th day, he was not able to get the title. He looked for it in his drawer where he had kept it before, but he could not find it. What are the repercussions? And is there any remedy? Is there anything that could help him to ensure that what I think could happen to him in relation to a sale agreement that he signed does not happen? How can you help him? And before helping him, what are the repercussions of him not delivering these completion documents after 90 days as he had agreed with the purchaser in the sale agreement?
I think this is a default, and when you default, the repercussions are that the innocent party have the right to repudiate the contract. They have rights provided by under common law to demand for specific performance, and what else did you ask? it's raining na nimekama mahali. I didn't get all the questions. Yeah.
Sorry about that. So yes, he has defaulted. I agree with you. He has defaulted. Now he's looking for a remedy. He wants to get out of that default. What options does he have?
I'll pass that one for now.
Okay, that is fine. That is fine. Donna, you can go ahead.
Okay. Hi, Levi.
Hi Donna, and I'm sorry, nilikusikia ukiniita saa zile, and I could not unmute myself to talk to you.
Okay, that's okay. It's a good thing you try. Mando hii tuko hapa sahi. Anyway, who teaches you commercial transactions?
Mr. Wakimani.
This semester.
Yes. He has been teaching us throughout.
Oh, even in first term.
Yes.
Oh, okay, that's interesting. Anyway, on to my first question. Can you institute a suit against the government?
Yes, you can institute us.
So how does one institute a suit against the government? What's the first thing you have to do before instituting the suit?
There's an act. I've forgotten the exact act. It provides on the procedures to be followed while instituting a suit against the government, and I've forgotten the name of the act.
So what's the first thing that you would do before you file your documents in court when you're instituting the suit against the government?
Allow me to pass that question.
Okay, that's okay. In probate, there is this principle called donatio motis causa. Have you heard of it?
Yes.
Yeah, what is it?
This is a gift given in contemplation of death.
Yeah, so that's true. So
in contemplation of death. Yes. Sorry.
What are the conditions that must be met for this gift to be valid?
It must be a movable property, and the donee, the donor, the donee must survive the donor, and the donor must die from the cause that he or she had contemplated when giving the gift. And another condition is that the donor must have given a means of accessing the gift, or he or she has delivered the gift to the donor, to the donee. Yes, I think those ones are the ones that I can remember for now.
So any case law that you can remember that speaks to that principle?
There's a case, Cain versus Moon.
Okay, that's good. And can a minor make a will?
No, a minor cannot make a will because he or she does not have capacity to do so.
What about persons of unsound mind?
Even a person of unsound mind cannot make a will. But there's an exception. he who alleges must prove that that person was actually of unsound mind while making the will.
Okay. So consider a situation where someone writes a will and then now wants some of the beneficiaries of the will to attest to that will. Is it possible for those beneficiaries to attest, and will the will be valid?
It is possible as long as they will add 2 more witnesses who are not beneficiaries to the will. It's not really, it does not inhibit them from being witnesses to the will, but they need to add 2 more witnesses for the will to be valid. If there are not 2 more witnesses, the will not be valid.
Okay. So under commercial, have you people been taught on the insolvency and bankruptcy?
Yes.
So what are some of the roles of an insolvency practitioner? In either bankruptcy or insolvency?
I'm trying to remember. Okay. An insolvency practitioner can be an insolvency, a trustee. It can be trustee, appointed as a trustee to run the estate of the bankrupt. I believe that is one of them. And an insolvency practitioner can also be appointed as an administrator. I'm not sure about that, but it's just an attempt on my side.
Okay, thank you. And then what are the 2 primary objects of bankruptcy?
I think one of them is to, how do I put this? To help the bankrupt, I'm attempting to help the bankrupt to help victimizing someone who doesn't have the ability. I'm using the wrong word, but to help not to victimize the bankrupt, and yet he or she has no means to pay the debt. I can only attempt that for now. I think I need to refresh my knowledge. I need to go through the bankruptcy again, insolvency.
Okay, then one last very easy one. Just 2 qualifications for one to be an insolvency practitioner.
One needs to be a lawyer, someone who has experience in the field of bankruptcy, practiced in the law of bankruptcy and insolvency. I think I need to refresh my mind.
That's okay. That's okay. Thank you. I'll the mic to Daniel, so that he can give his feedback first. That was good.
Thank you. Thank you. Yeah, it's Daniel. Okay, guys. So I'll give my opinion, or rather my thoughts on how that went. Now that was good. I think one thing that I like about you is Levi is man, the confidence. The confidence is good. I think when it comes to speaking in a way that I'd be able to hear what you're saying, I think I'd give you 100 for that. No matter what you come with me at, even if you're attacked in the morning, I'll say something. I will not go down, but I'll say something. So I think that is really good, and that's something that I can give you, that I give you for free. You won't go mute and freeze and be in a position where you're not able to say anything. So yeah, at least that composure is okay and is good. Now you can't appeal after applying for a review. That's an abuse of the court process. You have to choose one. So if you decide to appeal, that's it. If you decide to review, that's it. Now, the good thing with appealing is if you don't like the decision of that court, you can appeal again in a second appeal, where the court now will just deal with issues of law and not facts. So yeah, you can always, if you choose the way of appealing, then yes, you can appeal. You don't like the decision, appeal again. But if you decide to review, then that's it. After that decision is there, that's it. If you appeal, that's an abuse of the court process. Yes. Then I asked about completion documents. This is when you give the title documents and any consents that are required, so that the interest that you have in that particular property can pass from you to the next person. Okay. Now I asked you that this person, the 90th day has reached and he's not able to give his title. He put it in a drawer and he can't find it. What are the repercussions? I think the repercussions, you're clear. Hey, this is a default. And now under the contract, this person can decide and rescind the contract, can decide to repudiate it. He can decide and keep the 10% deposit, if at all that was one of the clauses in the contract. Now, it's very important that if you talk about the 10%, add that if it was a clause in the contract. The people who decide not to have the 10%, the people who decide. There's freedom of contract. So if it was a provision in the contract, then yes, you'll forget about the 10%. Yeah, you've talked about specific performance. Again, I'd like you to be yes, it's possible, but I'd like you to look at the situations where the court will actually force you to, do specific performance. Yeah, the damages must really be repairable. Yeah, so that's something that, again, you have to think about. Now, I asked you if that is the case and what are the repercussions. So what options does he have? Now, you do realize that in most contracts, unless it is not in that particular contract, they usually add this word, unless otherwise agreed between the parties. The 10% will be, retained by this particular, okay. Oh, by the way, you're the vendor. So the 10% will not apply here. But the other day I was doing a contract where the purchaser actually asked that, the vendor pays him 10% in the event that he's not able to give the completion document. So yeah, if that's a provision of the contract, then yes, you have to pay the 10%. Yeah, sorry for that. Yes, but if it's a provision, then you have to pay it. Now, I asked you about how he'd get out of it. Now, if it was provided for in the contract that they can renegotiate, there's always freedom to renegotiate. We can sit down with you and have a deed of variation where we are saying, yes, 90 days reached, but you are not able to find your title document. You've come to me and you're asking me, please, Daniel, just give me more. I know you've paid the amounts, you've paid everything. I'm the one in default. Please give me 30 more days. We can sit down with you, have a deed of variation where you're giving me more time to look for this title document, and that can actually happen. So that's an option. Sitting down, negotiating, asking for more time. And if the purchaser actually agreed to give you more time, then yes, well and good. But if he or she refuses, then too bad for you. Probably their Christmas came early. If you agree that you're going to give them the 10%, even though they're the purchaser, then you have to give them that particular 10% if that was part of the contract. Again, just to reiterate. Which other question did I ask you, Levi? That maybe you'd like me to clarify.
You talked about bails. I told you I can't remember them for now. Please help me to refresh my mind.
And remember, after asking you that, I just asked you. So anyway, let me just go through them. So your answer was correct. Anticipatory bail. Yeah, anticipatory bail is the one that you actually apply for in the circumstances that I have talked about. Yeah, and if you actually believe that these are trumped up charges, that is very important. It's not a blanket order. You must, and it doesn't cover you for everything. You must be specific, and you have to prove that particular offense that you are seeking anticipatory order for is actually a trumped up charge. Yeah. So of course the courts have the right to say yes or no. There's bail, there's police bail, where that one you pay at the cell before you go to court. There's bail pending trial, the one you pay before trial begins, in the one you apply for in court. Then there's bail pending appeal, the one that you can only get if you are able to prove that under the circumstances, your case has a high probability of success. Yes. So maybe if you just go through your notes again, you'll be able to see these particular types of bails. Then I asked you where you get that right. Where you are paying bail, who are you? It's very important that you answer that particular question for you to be able to answer which provision. So we have 49, an arrested person. We have 50, fair hearing. We have 51. So just to ask you again, Levi, where do you think we'd find that particular right?
49.
49 is an arrested. Okay. Just check. Just go through your constitution. Just go through your constitution, okay. Then you let me know. Yes, just confirm that. I think I'd like you to confirm that one. Okay. I don't think I asked you anything else, yeah? Levin?
Yes. Thank you, Daniel.
Okay. Maybe you have your constitution. Just Google. Maybe before, when Donna is done, you can tell me where that right is. Right to apply for right to bail. Yes. So Donna, you can take it away and give Levi your review.
Okay, so Levi, as Daniel has said, you made an attempt to at least try and scratch your brain, find where that information is, which is a good show, but endelea tu kusoma. Yeah, so the first question I asked you was whether you can institute a suit against the government, and yeah, the answer was yes. And before you institute that suit, what you need to do is to give the Attorney General the notice of intention to sue. So you deliver that to the AG, you serve them, and then you can now go ahead and lodge your suit after 30 days. So if they respond, you'll go ahead and lodge. If they don't respond after that 30 days, you'll still go ahead and lodge your suit. The second question, I'm not sure. But anyway, I asked you something about donatio mortis causa, and yeah, you got the conditions, and it's a gift in contemplation of death. Look at section 31 of the Law of Succession Act. The case is Kane versus Moon. Another question I asked was whether a minor can make a will. Yes, they can, but the will not be valid, and it can only be valid when they reach the majority age. So they can, but then it will just be a paper until now they have the capacity. For persons of unsound mind, it will be considered, yeah, you said that it will be considered whether at the time of making that will they were in their lucid moments, so that they were able to understand the contents of the will. What else? Yeah, for beneficiaries, where beneficiaries are supposed to attest to a will, yeah, that's true. Look at section 13 of the Law of Succession Act. There must be 2 additional independent witnesses. And the last questions were around commercial, and I think you really need to do a recap. Don't push back certain, don't push back certain units. And then, for commercial, who had to show me, it's wide. You'd think you understand, but then when you ask a question, you realize, wow, I thought I knew this, but you can't find the answer. So just do a refresher. Yeah. Don't forget a unit, LPM, LWD. Yeah. So for that, I'll leave you to the task. Is that okay?
Thank you. I will have to go through my notes. Actually, that's my plan tomorrow in the morning.
Yeah. And that was good. That was good. Just keep on reading. You have the confidence. And then I hear kwa exam room. It'll be good to go.
Thank you. Thank you. And then Daniel.
Yes.
I think it is Article 49H, 49(1)H.
You think, or you're sure?
I'm sure. I'm using the word think. I'm sorry. I'm
I'm
sure
telling
it
you,
is.
it's such an easy option. I find myself sometimes doing it so much, but it's not right. You have to say, yeah, okay, that's okay. That's okay, Levi.
Thank you. Thank you so much.
Sawa, guys. Welcome, sir. Welcome. I love your confidence. That composure is good, man. That composure is good. So just revision here and there, and you're good to go, man. You'll be firing on all cylinders. The sky is not even the limit. Okay, guys, it's 10:43. Angelo, do you have anyone else with a raised hand? Angelo, do we have a raised hand?
No, we don't.
Okay. For me, I'd like to call it a day. And I think that's okay. Now, we had some questions. Can you see them, Angelo? Sorry, I can't see them.
All right, let me just assist you with that. No, we don't have questions.
Oh, there's someone who asked, and I told him he can post in the.
But what was his name? Okay, there's a question
remember.
here. But I thought you answered it. Don't answer the question. It was 1-0.
Oh, okay.
Yeah, and it has been answered on in our chat.
Okay. Okay, guys. So there being no questions for me, I think it was a good session. And the turnout today was good. I think I have to say that the turnout was very, very good. And let's just keep pushing and keep going. I don't know. One thing that I learned with the orals is practice actually makes perfect. I think Erosumba would also tell you, and even Angelo, and Lim and Donna, you just have to keep trying and 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 trying. Just keep doing your best. Just keep doing your best. Just ensure that if you fail, then you don't lose hope. You keep going. You just have to keep going. Just don't lose hope. Just keep going. If you realize that actually confidence is the issue, that's why you should even do it again and again, so that you build that confidence. Okay? So please, even if the first time was the scariest, the what? Well, I don't know what to say. Moment of your life, it really scared you. That is why you need to do it again the second time, so that you are better and better. Okay, Donna, you've realized. Yeah, that's why you should do it again and again so that you get better and better. Okay, so that is what I'd like to say. But I think today people did well, and I'm proud of all of you. Osumba will go after me, then we can have Liam, Thomas. That was good. Then we can have Donna. Then Angelo will finish for us and get for us someone to pray for us so that we can close. But that's all from me, guys. Thank you so much. I will share the recording, I promise. Osumba?
Guys, you did well. Continue showing up, continue having these sessions. And as I indicated the last time we were here, if you're doing your revisions, kindly try to make use of past papers. They'll really help you to appreciate the manner in which questions are set. I wish you well. Have yourselves a fantastic night. Asanteni sana.
All right, mine is to wish you all the best. Just know that you are ready. So you just fine tune, keep on fine tuning, but believe in yourself that you are ready. Otherwise, have a blessed night. Let's meet the next session.
For me is to congratulate all people who volunteered today. You guys did well. Continue reading. It is through this that you'll develop your confidence and even answering questions in class. This is what actually helped me. I was very shy and very not confident, but just keep practicing both here, both out of here. Keep practicing, you guys will be good. And don't forget other units, the ones that you consider easy. So that's all. I wish you a blessed night. All the best in your revision. Yeah.
All right, all right. Since I have all the powers to call the meeting off, what I can say is to congratulate you. This was a major step that you have begun. Practice make perfect. I have a short story at 30 seconds. You see, there was one time Daniel was taking us through this particular session, but there was this particular day that I think I did not do well. And normally recordings are shared, orals were approaching, and you'd see sometimes you become overwhelmed, especially now when you focus on 4Cs, you have left behind, let's say, LPM, LWD, professional ethics, and you see these oral exams cut across. You don't know which unit or which course, and you don't know the lecturers you'll meet. So especially on LPM, then I don't know what is the problem. I don't normally get it. So I felt a lot of pressure. So what I did on Saturday, I was to have my orals now on Monday. I went to Karura Forest, put on my AirPods, and then as I ran, I was now listening through the recordings, and even I was laughing at myself when I was joking in the forest just to clear my head. So the reason I'm saying that is because it is here that you are going to make mistakes. It is here that you will correct those mistakes, and it is all about confidence when you go to that exam, and that confidence also needs content. Okay, like that, just raise your hand, volunteer, and as you do that, you will be actually getting it, because we can assure you almost 95% of the questions that we are asking you will be the same question that the lecturers will ask. The question is, are they going to be asked to you specifically? It may not be you, but it is going to be your colleague. If it is you, well and good. So just prepare yourself. I understand you have 2 weeks to submit your project work. Please, just compile as soon as possible. If you wait for that person to compile on that last day, some people are going to transnight. Please put your houses in order such that now you can focus on orals. And you see now there is no uh, much time that is left between orals and submission of project work. So whatever you have to do, if it is transniting now, just do it now so that you can have that clear mind. Having said that, thank you very much. We will see you guys again on Saturday. You have injected or you have rejected, I don't know, but keep safe, and we pray for you. Lim Odur, that is Donna, they were our uh, uh, I don't want to say 5-star, but they were great, our great participants last year. Hopefully next year we'll get members from your cohort. So please keep doing it. You see now they have their 9Ps, and that is why they are here. So let me just finish it there. Sharon Muendo, please pray for us. Thank you and good night.
Thank you. Thank you for the session. And thank you for the panelists for the amazing session. Yes, let me just keep it short and pray. Heavenly Father, we thank you for this night, and we thank you for our panelists. We thank you for the clarity that have been, the process that we've been through, and Lord, you see our efforts, and may you stand with us, may you be with us, and may you also help us so that we may be better. May you also help us so that we may you see our efforts so that we may be able to accomplish our 9Ps. And as we're going to rest today, Lord, may you protect us and guide us. In Jesus' name we pray. Amen.
Amen. Amen. Great week
Amen.
ahead.
Amen. Good night, guys.
Good night. Members can leave at their own pleasure.